Good afternoon, everybody. Thank you for joining me this afternoon to talk about family law implications for schools. It's a little bit about myself. I've been practicing in family law for over 15 years now, and I'm an associate here at Michael Lynch Family Lawyers. We are a specialist family law firm, and we've been operating for 22 years. We have regular articles and publications, and we offer a fixed cost initial consultation for $330, including GST. We'll spend as long as we need to in that consultation to talk about all the issues in the matter and offer ways of resolving them. Now, unfortunately, up to 40% of marriages in Australia end in divorce, and that doesn't include de facto couples who separate. This is an overview of the things or the topics I want to address today with you. Hope some of these topics I'll just touch on, and others I'll go into some more detail. So hopefully today I'm able to provide you with a general understanding of the practical aspects of family law that you might be exposed to at your school with your school children. So let's get started. The legislation that governs family law is the Family Law Act, and it covers all children and all property matters. It's activated by separation of parents or parties that care for children. There have been many changes to the family law legislation over the years, and I'll talk about those changes in some more detail later on in my presentation. The courts that I appear in regularly as a family law solicitor are the Family Court and the Federal Circuit Court. This was formerly the Federal Magistrates Court. The Family Court deals with more complex matters, that is, more complex property matters and parenting matters that have other complex issues involved. For example, international relocation, where one parent wants to move with a child overseas, or cases in which there are allegations of child sexual abuse. The Federal Circuit Court was set up in 2000 to deal with shorter and simpler family law matters. The Federal Circuit Court Acts directs the court to operate more informally and to use streamlined processes. Here's a list of legal terms and processes that come up regularly in family law matters. Most of these I will speak about later on in my presentation. I won't go through all of them now, so if you do have any questions about any of these, please don't hesitate to send us an email or put it in your questionnaire at the end. The possible legal issues facing parents of school children, there is divorce, that is where parties legally separate, and they do this by waiting 12 months after the date of separation and then making an application to the Federal Circuit Court for divorce. So there does have to be that 12-month separation first. Then there are parenting matters, child support, that is the financial support of children, property settlement between the parties, spousal maintenance. Spousal maintenance is where one parent has relied on the other parent to financially support them during the relationship, and therefore after the relationship they can seek a payment of spousal maintenance until there's a property settlement. There's issues of domestic violence, which I'll talk about later on in the presentation, and paternity and change of name. I want to touch briefly on mediation and family dispute resolution, because I think this would be a term that you come across from time to time as a principal, teacher, or guidance counsellor at schools. So what is it, and do parents have to do it? A mediation process is undertaken by parents to try to reach a decision without having to resort to court processes. It is a voluntary process unless the court makes an order for parties to attend a mediation, which they do from time to time, mainly in property matters, but sometimes in parenting matters. A parent doesn't have to be legally represented at a mediation, but it can most of the time be quite helpful to have legal representation. There are different types of mediations. There's a shuttle conference. That's when the parties are in separate rooms and the mediator goes between the two rooms. There could be a round table conference where all parties and legal representatives and the mediator are at one table. Or a dual mediation where there's two mediators present. In parenting cases, before a person can apply to the court to seek a parenting order, they are supposed to show the court that they've tried to resolve the matters first, and they do this by presenting a Section 60I certificate to the court when filing their application. So a Section 60I certificate is obtained from a registered family dispute resolution practitioner. Not all counsellors are family dispute resolution practitioners, but there are many family lawyers and barristers who specialise in family law that are approved to be dispute resolution practitioners. There are family dispute resolution centres called family relationship centres across Australia, operated by different contracted organisations. Like I said, it is critical in children's matters to have that Section 60I certificate. It shows the court the parties have tried to resolve their disputes first. There are some exceptions to the need to present that certificate, for example, in urgent matters or matters where there is domestic violence. The next topic is children. Beware the changes. The Family Law Act has had many changes, but the significant ones were in 2006 and again in 2012. The best way for me to convey to you the significance of the 2006 changes is to give you an example of the general type of order that may have been made in an average family law matter prior to 2006. An order may have provided for the non-resident parent or contact parent to spend 2 nights per fortnight with their child, i.e. alternate weekend time. But since the 2006 legislative change, it's quite common for courts to make an order for a child to spend 5 nights a fortnight with a parent. That's considered substantial and significant time. Now, I stress this is a sweeping statement designed to give you a quick understanding of the practical impacts of the 2006 changes to the Act. Here are a few terms that you may hear from people going through a parenting dispute. But I just want to point out that there have been changes in the terms. So before 1996, the terms used were guardianship, custody, and access. After 1996, it was residence, contact, and specific issues. And then since the 1st of July 2006, the terms used are a lives with order and a spends time with order. In a parenting matter, the court's main principle that guides their decision-making process is what is in the children's best interests, and the best interest is paramount. Usually both parents should have a high level of meaningful involvement, and parents should try to agree, which is why the court introduced the need for a Section 60I certificate. The two main issues in parenting matters is how parental responsibility should be divided between the parties and what living arrangements should be in place for the children. Parental responsibility could refer to just day-to-day issues, that is, who has the day-to-day responsibility for a child, and it's usually the person who, if the child is in their care, they would have the day-to-day responsibility for the child at that time. But major long-term issues is covered also by parental responsibility, and that can cover issues such as education, religious and cultural upbringing, health, a child's name, changes to a child's living arrangements that make it significantly more difficult for a child to spend time with a parent. There is a presumption in the legislation for equal shared parental responsibility. That presumption can be rebutted, though, in matters where there is, for example, domestic violence. The presumption aims to ensure that parents share the key decisions in a child's life, regardless of how much time that child spends with each parent. Parents need to be able to communicate and consult with each other when making decisions about their child's life. In 2006 saw significant changes to the Family Law Act via the Family Law Amendment Shared Responsibility Act of 2006. One of the main principles is that children have the right to know and be cared for by both of their parents. The amendments introduced a presumption in favour of equal shared parental responsibility, but also a greater need to protect children from being exposed to family violence. There was an effort to place greater emphasis on the need for both parents to be involved in their children's lives after separation. So how the court is to consider the best interests of a child is set out in this section 60cc of the Family Law Act, and it sets out the legislative path that a judge follows when making decisions about parenting matters. The court must consider whether a child spending equal time with each of the parents is reasonably practicable, and if it is, consider making an order for equal time. Failing that, they would consider then making an order for substantial and significant time. But there were further changes to the Family Law Act in June 2012, which provided better protection in family law cases where there was family violence and abuse. The main change being an update to the definitions of family violence and child abuse. Previously, there was a requirement that a person reasonably fear for their safety, but the new definitions brought in 2012 provided that family violence is violent, threatening, or other behaviour by a person that coerces or controls a family member or causes the family member to be fearful. The best interests are still the paramount consideration. So looking a little more closely at this concept of best interests, the primary considerations for the court are the benefit to a child of having a meaningful relationship with both parents, and the need to protect the child from physical or psychological harm and from being exposed to abuse, neglect, or family violence. The court must also look to additional considerations, including a child's wishes, that is, any views expressed by the child, taking into account the child's age and their level of maturity, any practical difficulties and expenses of a child spending time with and communicating with a parent, the parent's capacity to provide for the needs of the child, including emotional and intellectual needs. The court must also consider the attitude to the child and the responsibilities of parenthood demonstrated by each of the parents. The courts will place reliance upon whether a parent is child-focused, the maturity of a parent, and look at the long-term parenting issues such as attitude to schooling, childcare, television, diet, etc. So the next topic is parenting agreements. First of all, what is a parenting order? A parenting order can deal with a variety of issues: where a child will live and who they will spend time with, who a child will communicate with and by what means and how often, who has parental responsibility for a child, and where a child will go to school or who is to make that decision, whether a child can travel overseas or move away. Sometimes a verbal agreement or informal agreement is sufficient. This way, parents can continue to co-parent without the need for anything more formal in place. But for this to work, parents continue to discuss their children's needs by putting aside their own emotions around the separation. Parents are able to put the children's best interests first, and the benefit is it allows flexibility to the parties and child. The next step up from that informal agreement is a parenting plan. A parenting plan where care arrangements are put into writing based on agreement between the parties. If there's a low level of formality involved, it doesn't need to be prepared by a solicitor. Both parents can prepare it themselves, but it does need to be signed and dated by both parents. There's no standard form. It's quite flexible. There's minimal cost to the parties because they can prepare it themselves. However, importantly, a parenting plan is not legally binding or enforceable. If a matter does end up in court, a parent cannot rely on a parenting plan. It's just one piece of evidence before the court. The court must have regard to it, but they will look at all the evidence. What it does provide, though, is evidence of a parent's intention at the time of signing the parenting plan. So, as a principal, school teacher, or counsellor, you might be provided with a copy of a parenting plan, and it's important to be able to distinguish a parenting plan from a court order or consent order. One of the main distinguishing features is I've given an example of what the stamp or the court seal looks like on a court order, and whether that's a consent order or a judge-made order, they both have the same weight. But you'll find that these orders do bear this seal, and it'll either be the Federal Circuit Court of Australia or the Family Court of Australia. Consent orders are negotiated agreements between parents. Parents can negotiate by themselves or with the help of a solicitor. It's formalised by preparing two documents to be filed in the Family Court Registry, which are signed by both parents, the consent order and the application for consent orders. So the parents themselves don't go to court, just the documents go into the court registry. A registrar will then look at the orders, and if they're happy with them, they'll make them into a court order by sealing it with the court seal. Once the court order is made, it can only be changed by further order of the court or by consent between the parties, and it has the same weight as if the parties had been through the court system and a judge had made those orders. It's important to remember that these orders stay in place until the children turn 18 years of age. They are legally binding and enforceable. I'll touch on domestic violence only because I thought this might be something relevant to issues that arise in your school. The domestic violence itself is a broad topic and is usually covered by an entire presentation in itself. In Queensland, it is the Domestic and Family Violence Protection Act of 2012. That legislation was updated again last year. It is state-based legislation, so what that means is that each state has their own domestic violence legislation. And in Queensland, it is the Magistrates Court that deals with these issues. So the most significant change in 2012 was to broaden the definition of domestic violence. It's behaviour by a person towards another with whom the first is in a relevant relationship that is physically or sexually abusive, emotionally or psychologically abusive, economically abusive or threatening or coercive, or controls or dominates a second person to cause them fear for their safety or well-being or that of somebody else. I've just given some examples here of different types of actions that could be considered domestic violence. So if you just have a read of those, I will add to them as well now. So for example, as well as unlawful stalking, following a person, or preventing a person from obtaining employment, coercing a person to sign for finance, coercing a person to obtain social security benefits, repeatedly texting or emailing a person. In relation to the further changes that were made last year in May, final protection orders are now for a duration of 5 years as opposed to the previous 2-year orders. A court can only make an order for less than 5 years if there are sufficient reasons for the order to be for less time. The standard condition is that must be included in all domestic violence orders is that the respondent be of good behaviour and not commit domestic violence against the aggrieved. The court must hear cross applications together, and what that means is when one party files an application for a protection order, sometimes the other parent will file a cross application as well. And the court has to consider any existing family law orders and whether that needs to be varied or suspended if inconsistent in order to protect the victim or the aggrieved. A court's required to consider ouster conditions in all domestic violence applications. This is an order for the respondent to be excluded from the home of the aggrieved. In terms of practical issues for schools, you might be handed a copy of a domestic violence order by a parent, and it might contain an order that a respondent not approach within 100 metres of the child's school. Also remember a parenting order, i.e. that is found in a consent order or court order, overrides any inconsistent clause in a domestic violence order in terms of a time a child is to spend with the parent. So what this means if that a parenting order provides for a mother to collect a child from school on a Wednesday afternoon, but there's also a domestic violence order in place, that the mother can still go to the school if it's in line with the parenting order found in the court order. Now I'll spend some more time talking about specific issues for schools. These are the topics I'm going to explore next. So what information should a school be provided when there's a family law dispute? How does your school deal with parenting arrangements or problems? What if a parent wants to change a child's school? And examples of terms contained in court orders relevant to schools, as well as orders to watch out for. So what information should separated parents be providing to your school? A parent should make a child's school teacher aware of a separation, which enables the teacher to pay extra attention to the child during class and also for the purpose of recommending involvement of a school counsellor if required. A separated parent should not change or remove the other parent's details from the emergency contact details held by a school just because of a separation. Really, both parents' contact details should remain with the school. Obviously, there are some exceptions to that. For example, if there was an order that one parent have no time with a child, that might be a reason to remove that person's contact details from the school. So if separated parents do have that sealed court order, then they should provide a copy to the school, because once a parenting order is made, it becomes binding and enforceable on the parties to the order. So the school is a third party. They're not bound by the order, but they should be aware of what it says. Parents should take positive action to comply with the order, including encouraging a child to comply with an order. So it's not good enough to say, oh yes, there's an order that Johnny spend weekend time with Dad, but he didn't want to go, so I didn't make him go. You might find yourself in court facing a contravention application. How does your school deal with problems with parenting arrangements? So, a school should be careful about their involvement in parenting disagreements over where a child lives or who a child is spending time with. If a parent is involved in court proceedings about a child, they may decide to issue a subpoena to the school to obtain records for court proceedings. I'll talk a little bit more specifically about subpoenas shortly. Sometimes a teacher might be asked by a separated parent to write a letter or report about a child for court proceedings, or to have evidence put into an affidavit of the teacher. Be careful about such requests unless you as the teacher are happy to be a witness in the case. When you go on affidavit, you can then be called to be cross-examined at a trial. Obviously, a child's regular attendance at school is extremely important in complex or litigious family law matters that involve parenting. It's often the case that a parent or an independent children's lawyer will issue a subpoena to the school to look at the child's attendance. So what if a parent arrives at school to collect their child and the other parent's already taken the child without the first parent's consent or permission, where there is no court order? A school can only work to a court order and should be cautious of any involvement in a parenting dispute. A parent should try to contact the other parent first to find out why they took the child if they don't already know the reason. And the parent should try to speak to the child to make sure they're all right. If a parent's unable to contact the other parent or child, they can contact the local Queensland Police and ask them to do a welfare check. The Queensland Police will normally be reluctant to become involved any further apart from a welfare check because parenting matters are considered the Commonwealth jurisdiction. And a school should not be put in a position of enforcing a parenting arrangement. If a parent needs assistance, they should obtain legal advice about their options, and their options will depend on how their agreement, if any, is documented. So what this means is if you have a parenting plan, it's not enforceable, whereas if you have a court order, then you can go back to court and enforce it or issue a contravention application against the other parent. But it's usually not a good idea for a parent to keep a child away from school just so the other parent doesn't try to take them from school. This will usually backfire on them. Preemptive action could assist the school so that you're prepared for any incident before it occurs. If a parent is worried the other parent may try to collect a child from school without their knowledge or consent, they can put the school on notice in writing that they don't agree to that occurring and that they are to be contacted immediately should the parent attend the school. What if a parent wishes to change a child's school? What school a child attends is often a sticking point between parents and can quickly lead to a tug-of-war match. But for the school's information, it's important to note that parents should not change a child's school unless, firstly, both parents agree. That is, does the school have a signed enrolment form and is it signed by both parents or only one? Or does that parent have a court order giving them power to make the decision? And next I'll show you an example of such an order. It's much better if the parents can reach agreement between themselves without having to resort to court action, remembering that an application to court won't be resolved quickly. So if parents were to have a dispute about what school a child was to attend and they were to make an application in, say, September for the school year the following year, it's unlikely that that application would be resolved by the court in time for the school year. It might even take another year to resolve it. And a court will be deciding the application based on the best interests of the child, not the best interests of the parent. On the next 3 slides, I've given some examples of orders that appear in a court order that would be of interest to schools. I won't go through each of them individually because they are written out there, but hopefully that will be helpful for you in circumstances where you're handed a parenting plan or court order by a parent. And you can have a scan and see if any of these arise. Probably one of the most common orders included is that each parent have authority to contact the child's school to request copies of all school notices, information, newsletters, and school reports to be sent to them at their own cost. I spoke a little earlier about when one party does obtain an order to make a decision about a school, or where both parties need to make that decision, or the court orders that a child attend a certain school. What that will look like is that both parties do all such things and sign all such documents to enrol X at X state primary school. Now, it's often the case that a court makes an order that changeovers occur at the child's school. What that means is that one parent will drop the child at school in the morning, and then the other parent may pick the child up from school in the afternoon. It just means that the parents don't have to come into contact with each other, which lessens the tension and makes it more comfortable for the child. So in relation to these orders I've put here, you can download the PowerPoint by clicking the handout button. I wanted to just point out that in some circumstances, there might be some very specific orders about a child not to spend any time with one parent. And this is what these orders will look like. I think it's important for the school to be aware of it, because if that parent did try to approach a child at the school, the parent should be that the school should be contacting the other parent immediately. There could also be an order for only supervised contact between a child and parent. And again, the school should be aware of that, because supervised time means that there is a third party supervising the parent with the child, and that supervisor would always be within sight and hearing of the parent and child. Sometimes it is at a private contact centre. Subpoenas. I'm sure from time to time you've had subpoenas issued to your school. Usually it's a subpoena to produce documents, but occasionally it might be a subpoena to attend to give evidence at a trial. You are entitled to be paid conduct money. The minimum amount is $25. And in fact, if that is not paid, you do not have to answer the subpoena. Probably what I would suggest, if that was to occur, contact the person who has issued the subpoena, the party, and remind them to pay the conduct money. There are penalties if you don't comply with the subpoena, which is considered contempt of court. The penalties can also include a warrant for your arrest. You may be liable to pay any costs occasioned by your failure to comply. If you are subpoenaed to attend court to give evidence, you can ask for your costs of attending court. There's also ability to object to a subpoena on limited grounds if you consider the subpoena irrelevant or too broad. I'll just look at this one, this slide, which is an example of what the front page of a subpoena looks like. I'll just find it for you. I just wanted to point out to you, if you've never seen a subpoena, on the front page, there are some boxes in the middle. This is where you'll see whether you need to attend court to give evidence or whether you're just to produce documents to the court, which is usually what happens when a school's involved. And at the top right-hand corner of the subpoena is the date that documents must be produced to the court registry, remembering that documents are to be produced to the court registry and not sent to the party that has issued the subpoena. The reason being that parties in a matter who have issued a subpoena still need to get leave of the court to inspect those documents. You might find yourself issued with a subpoena in a family law matter or a domestic violence proceeding. Also included in the subpoena document will be a list of the documents that the party requires you to produce. This is where you've been subpoenaed to produce documents to the court. And usually it's these types of documents that you're asked to produce, which I've listed here. I'll just touch on what an independent children's lawyer is if you've heard this term used. An independent children's lawyer is appointed by the court. They are solicitors practicing in family law who have been approved to practice as independent children's lawyer. Usually in complex parenting matters, the judge may make an order for an independent children's lawyer to be appointed to a matter, or the parties themselves might ask a court to make that order. They work to ensure that any views expressed by the child are fully reported to the court in an admissible form, which is usually a family report. An independent children's lawyer must act in the best interests of the child, but not necessarily act on the wishes of the child unless his or her wishes are also consistent with their best interest. You may find you have communication with an independent children's lawyer, and this is because when an independent children's lawyer is appointed to a matter, they'll send each of the parties a number of authorities which they ask them to sign and return. And usually one of these authorities is directed to the school. This is what one of those authorities will look like. I just wanted to touch on family reports also, because from time to time you may hear a child talking about the family report process, or they may have time off to attend the family report interviews. Usually interviews are conducted over the course of a day, and the family report writer, who is usually a counsellor or psychologist, does require both parties and usually the children to be involved in that process. So a family report is usually only when matters are already in court, although sometimes parties do obtain a family report first before going to court. The purpose of the reports is to assist a judge to make a decision about a child. It provides information about the views of the child and factors that underpin those views, as well as their relationships with their caregivers and the capacity and insight of the caregivers. And occasionally, children will be asked to attend an 11F report at court. That's called a child inclusive conference. It's a shorter form of the family report process. A judge may order this type of report in urgent matters or matters where the court needs a quick glimpse into the family dynamics. It is prepared by counsellors at the court and hopefully will give the court enough information to decide the next steps in the case or make some interim orders about care arrangements. I just wanted to point out here that family reports and affidavits filed in family court proceedings or federal circuit court proceedings are confidential and should not be shown to any other person who is not a party to proceedings. So if a parent at your school was to hand you a copy of the family report, beware that they should not be doing that. It is a breach of the publication provisions of the Family Law Act. We do offer free seminars for your school staff if you wanted to know more, or you've got any specific topics relating to family law that you need some answers to. We can come to your school and give you a more in-depth presentation. Thank you so much for listening this afternoon. I hope that that's shed some light on issues that probably come up at your school in parenting disputes. If you've got any questions, questions out of today's presentation, please send us an email to law@mlynch.com.au. And if you could answer the feedback survey, that would be fantastic. And just a reminder that we do offer those fixed fee initial consultations for $330, including GST. Thank you and have a good afternoon.